Hello, everyone. Welcome to our webinar on representing LGBT asylum seekers. My name is Anisha Gandhi, and I'm a managing attorney at NIJC. And I'm one of three presenters today. My colleague, Tania Linares Garcia, and Michelle Velasquez will also be joining a little bit later. Together, we do the majority of the pro bono support at NIJC's LGBT Immigrant Rights Initiative. So if you have a case with us already, you always should feel free to reach out to us with any questions and concerns. And if you do take a case, we will be likely in contact with you. One or multiple of us will be in contact with you. Just a few housekeeping items. First, you'll see on the right-hand side, there'll be an area where you can ask questions. We're not going to do questions live. We're going to be trying to answer them as we go. If your question doesn't end up getting answered, please feel free to reach out to us at the end, and we'll get a response to whatever question you had. And if there's time at the end, we may have some further discussion of the questions that came up during the presentation. You'll also see on the right that there's 3 handouts. One should be like a PDF of the slides. The other one is our pro bono manual, and the third is a chart of the current attacks on asylum law, the current status of those cases, and the impact of those attacks. We will briefly mention this at the end of today's presentation, but feel free to download that and take a look. You can also find the last 2, the pro bono manual and the chart, on our website. And if you can't find it, you can always feel free to reach out to us and we'll send it your way. Lastly, on housekeeping items is CLEs. So just a friendly reminder that that attorneys in Illinois who are requesting CLEs need to make sure that we have the ARDC numbers. So if you didn't enter that during registration, you need to email us with that information. And we will be emailing certificates to all participants after the webinar. And attorneys who are licensed in other states, I believe you can use those certificates to request CLE from your bar. And just really quick, we're really excited that we have so many individuals joining us today. And just a reminder that this is intended for attorneys, and for those who are not attorneys, please just be mindful of the unauthorized practice of law. All right, so let's get started. So next slide. So for those unfamiliar with the National Immigrant Justice Center, NIJC is an agency of Heartland Alliance, which is a broad-based social service organization based in the Midwest, but also operates nationally and internationally. NIJC is, as far as I know, the only legal service provider within Heartland Alliance. Our mission is we're dedicated to ensuring the human rights, protections, and access to justice for all immigrants, refugees, and asylum seekers, both at the individual and systemic level. And we work often in kind of 3 pillars. So our legal services, we provide all aspects of immigration legal representation outside of employment-based immigration, student and tourist visas. On average, we provide legal services to 10,000 plus immigrants, refugees, and asylum seekers each year. And we provide this representation in detention, unaccompanied children, victims of crimes, family-based petitions, and then of course for our asylum seekers. What's unique about NIJC is that we not only provide that broad-based, high-volume kind of legal representation, but also the same kind of work in our impact litigation and advocacy and policy work. So the other 2 pillars being the impact litigation, and then second is our advocacy and policy work. And we believe that this is critical to our work to have these 3 things combined, because we're able to build off the information that we learn from our direct representation work, and then use that information to further our impact litigation and policy work. So we see many issues popping up during direct representation, which we in turn use to inform members of Congress, or as to what is going on, or to challenge the unjust asylum restrictions we are seeing. So it is not uncommon for pro bonos who take cases to encounter these issues during your representation, and that you can inform us about that, and then we can help escalate that and try to make some systemic changes there. Lastly, about NIJC is we operate with 5 different offices across the country. We have a dedicated staff of 120 individuals, And we support, and we have the support of nearly 2,100 pro bono attorneys that are actively working on cases right now. So a little bit more about our pro bono work. Just, the first thing we always kind of tell people is you don't have to be a litigation attorney. You shouldn't feel intimidation when taking these cases. It's so important, as you can see, that to take a case, that representation really matters. Non-citizens do not have the right to appointed counsel, but are 5 times more likely to obtain relief if they do have counsel. And if you are interested in any of the other pro bono work that we may do, next slide, please, sorry. My bad. So if you are interested in any other of the pro bono work that we do have clinics on naturalization and DACA and asylee and refugee adjustment. We also have special immigrant juvenile status, SIJS predicate order pro bono work, and VAWA and U visa relief opportunities. And so if you're interested in any of these works, you should definitely check out our website so that you can learn more about those opportunities. Today, we're just going to be focusing on asylum, as you all know. Next slide. So just a little bit more about how our clients come to us, and then the resources that pro bonos that we provide for pro bonos. So individuals usually contact us through one of our NIJC offices, either in Chicago, Indiana, or San Diego. They come to us through connections with community organizations or our detention and LGBT hotlines, our help desk at the Chicago Immigration Court, and often just through word of mouth. And then we conduct an in-depth case screening and assessment of their cases. And so for NIJC's LGBT project, which is kind of short for the LGBT Immigrant Rights Initiative, we are looking for whether the potential client first is income eligible for our services, and then second, do they have a viable case, and that being based on what may have happened or may happen to them in home country, and what it is like where they're from. And then also look to see if it's a good case for pro bono representation, or if whether it's a case that we would want to keep in-house. And if we accept a case, NIJC signs a retainer with the client and then begins looking for pro bono placement. So this means we agree to represent an individual even if we are unable to find pro bono representation. Once a pro bono attorney or team accepts the case, NIJC remains of counsel and provides attorney support, document review, technical assistance throughout the case, and so forth. However, the case mainly becomes that of the pro bono team, and so you will be meeting with the client, working on the filings, making sure you're in regular contact with clients, and we'll talk more about what that all means on Thursday during part 2 of our presentation about presenting and preparing your client's case. And then, we realize that many of our pro bonos are still learning about the immigration system. So for the first time, which is totally okay, we are here to support you throughout the life of your case, right? So we have our, one on our website and attached in the documents, our pro bono manual, which really walks through the law and explains the process. So don't take too many notes today. You'll have access to that either by downloading it from the handouts today or from our website. We also have we also have on our website recorded trainings, frequently asked questions, practice advisories. We'll be mentioning those here and there during the presentation. And of course, we're always here. As I mentioned before, Michelle, Tanya, and myself, we all work on pro bono cases. And so we're always there for you all to contact us for sample briefs, cover letters, for LGBT asylum cases, up-to-date country conditions, which the LGBT team keeps up to date, that you can then use and tailor to your specific client and their case. And then you can also, of course, ask any kinds of questions to us around interpretation, or what your judge is going to be like, or what to expect at asylum office interviews, any and all those kinds of questions and concerns that may pop up during your representation. We're always here to help out with that. Next slide. Yeah, so as I mentioned, this is part 1 of our of our 2-part webinar. Part 2 is on Thursday, and that will go over presenting and preparing an asylum case. But today we're going to just do a quick LGBT 101 and then also dive into the basics of asylum law, knowing that we're not going to be able to cover everything, but always looking at that pro bono manual and of course contacting us if you have questions, and then breaking it down by the elements of asylum. That will just go further into each element of asylum. And again, this is part 1 of a 2-part series, and so please, of course, join us on Thursday as well. And next slide.
All right, thanks, Anisha. Good afternoon, everyone. My name is Michelle Velasquez, and I am the LGBT Pro Bono Coordinator at NIJC. Today, we'll be going over some terminology that the LGBT community uses, and that will be important to familiarize yourself with when it comes to representing LGBT individuals. So the first thing we wanted to make a point of is that words matter, and words may weigh more for someone else than for yourself. The topics that I will be discussing might seem basic, but the ways in which we talk to our clients are very important. Words impact clients directly and can be a way to form or break trust with them. And we believe that everyone deserves respect, no matter if they are LGBT or not. More so than in many other cases, the words you use to speak to your client and about their case will affect their willingness to open up and to trust you. And then also to keep in mind that your clients may have a claim of persecution that involves being bullied and called derogatory names. So it's important for you to be sensitive as to the words you use. So this is a preview of terms you may encounter when representing an individual from the LGBT community. We will be going over some of these terms more in a bit. And of course, there are way more terms that LGBT or queer folks use to identify, but we'll only be focusing on only some of them today. Again, it's important to be aware of what these words mean, and it is important to take a step in familiarizing yourself with these terms in order to make your client feel comfortable and safe. Avoid using words that may potentially hurt your client. If there are words that they have used before and define them as being derogatory, refrain from using those same words. At the end of the day, your client chooses how to identify, and you will need to respect that. For example, it's important to address your client by their pronouns, which we'll go into what that means, and we'll also define why pronoun usage is important too. And then the last 2 things would be that when you aren't sure of a word or a term that your client uses, or if you simply don't know the meaning, it's important that you ask, but with, of course, intention and respect. And the last thing would be that when mistakes happen, and they will happen, it's okay. You can apologize, learn from that mistake, and move forward, and that is the best for that situation. Now we will talk about some terminology and go into some of these definitions. The first up is sex. Sex is the classification of people as male or female or as intersex. At birth, infants are assigned to a sex, usually based on the appearance of their external anatomy. And this is what usually is written on a birth certificate. However, a person's sex is actually a combination of bodily characteristics, including chromosomes, hormones, internal and external reproductive organs, and secondary sex characteristics. A person who is intersex, it has a condition in which someone is born with a reproductive or sexual anatomy or chromosome pattern that doesn't fit the typical definition of male or female. Next is sexual orientation. This is an umbrella term that describes a romantic physical attraction to others. Usually the words we see to describe this are homosexual or homosexuality, and these are words used to describe individuals who are attracted to others of the same sex. And although this is the term that the court is most likely to use to discuss your client's case, it is often considered clinical and slightly derogatory, so you should avoid using it in your own brief. Some alternatives would be swapping these words with swapping homosexual with lesbian or gay as appropriate, and also, of course, as how your client identifies. People may also identify their sexual orientation as gay or lesbian, and these are folks who enduring physical, romantic, or emotional attractions are to people of the same sex or gender. Bisexual, people whose romantic and or emotional attractions are to people of the same or different sex. There's also queer, and this is mostly for sexual and gender identities other than straight or cisgender. LGBT folks may all identify with the word queer, but of course it's always safe to ask and not to assume. And then the next word is gender. Gender is a social construct, and it's usually expressed in binary terms of woman or man. And then we have gender identity, and this is the gender one knows themselves to be. For trans folks, their gender identity often does not align with their gender assigned at birth. Some trans identities include trans woman, trans man, genderqueer, gender fluid, bigender, and those are just to name a few. There are also culturally specific terms like two-spirit, which usually is used by the indigenous or native community and should not be used by people outside of those communities. And then terms to avoid are words such as transgendered or transvestite, and you can see on the slide other terms that you to learn to avoid. And then more specifically, avoiding the word transgender is important because when we say transgendered, it might imply that something that being transgender is something that happened to a person rather than reflecting who they actually are. And the word transgender should only be used as an adjective. Other ways that folks may identify may be gender nonconforming. These are individuals whose gender expression is different from societal expectations. And non-binary, someone who does not identify as exclusively a man or a woman, and a non-binary person may fluctuate between genders or express multiple genders at the same time. And then the last word we have on the slide is gender expression. This is how a person expresses their gender identity through self-expression, actions, behavior, dress, etc. And something important to note is you might not know someone's gender identity just based off their gender expression. And just before I go into the next slide, you can see the common acronyms that are used to shorten some of these terms. Sexual orientation and gender identity can be shortened to SOGI, and GNC meaning can mean gender nonconforming. So here we have the gender unicorn. It's a resource developed by the Trans Student Educational Resources that shows the differences between gender identity, gender expression, sex, and physical and emotional attraction. Notice that the gender identity and gender expression, sex, physical and emotional attraction exist on the spectrum. Something to flag is you must be flexible and open to changes people may have regarding their sexual orientation and/or gender identity. Some clients understand their sexual orientation or gender identity more fluidly or more rigidly than others. And also, it's important to understand that some clients may feel they, and I think this is more specifically for trans clients. Some clients may feel that they were born gay, and others may not feel, will not come to understand that they are queer or trans until they're adults. Some clients will come out as trans after we've begun working with them, so it's good to give them the space to be open with you if their feelings about their gender or their sexual orientation change over time. So one of the last points we'll touch on are pronouns. Gender pronouns specifically refer to people that you are talking about. If you must ask which pronoun someone uses, we suggest maybe starting with your own. For example, introducing yourself as, hi, I'm Michelle, and I use they, them, and she, her pronouns. What about you? And then be intentional about using your client's pronouns from then on, and also encourage others to do so. And as you can see in the slide, these are pronouns that are commonly used, and we've included gender binary and gender neutral pronouns on here too, as well. So we will keep talking about how to work with LGBT clients in part 2, but for now we wanted to ensure everyone was familiar with the vocabulary. These are some resources and glossaries that you can refer to learn more about LGBT terminology. And then at the end of the presentation, we'll let you know how to refer back to these glossaries. And now we'll talk more about the basics of asylum law, and I'll turn that to Tanya.
Thanks, Michelle. Hey, y'all. I'm Tanya. As Anisha mentioned, I'm another attorney in the LGBT project. And we're going to talk more about the basics of asylum law. We are going to focus on asylum, though we are going to briefly touch on other forms of protection, such as withholding and CAT. And we do want to acknowledge that while there may be some cases that are more complicated as to some or all of the elements of asylum, as long as you have a good understanding of the basics, we think that that would make even a more complicated case more go smoothly. So we're going to introduce a poll to gauge who's in the audience and how much experience you all have. And please feel free to complete it. Great, thank you. So it sounds like there's quite a few of us that are just starting out with asylum law. Welcome, everyone. We think this is going to be a good training, a good starting point for you to be able to take on some cases. So if we go to the next slide, it gives us a little bit of an overview of all the agencies and entities that may be involved in processing and adjudicating an asylum claim. You know, obviously we have the asylum seekers and the attorneys involved. If your client is a child, or your client has a child who is in the custody of the government, they will be in the custody of the Office of Refugee Resettlement, which effectively manages the detention of immigrant children, right? If your client is in removal proceedings, they likely had interactions with the Department of Homeland Security, right, which houses both ICE and CBP, is in charge of all the enforcement and removal proceedings. But also, if your client is applying for asylum affirmatively, they will be dealing with the Department of Homeland Security through the USCIS office, which handles affirmative asylum applications, and also affirmative applications for a variety of immigration benefits. Lastly, if your client is already in removal proceedings, DOJ will be involved because the Department of Justice houses basically all the immigration courts and the Board of Immigration Appeals. So if we go to the next slide, we can talk a little bit more about what it means to have an affirmative versus a defensive asylum claim, and what the process of seeking asylum and appealing those decisions is like. So affirmative asylum is someone who's seeking asylum affirmatively is someone who is not in removal proceedings. Those folks most usually are someone who entered with a visa and has overstayed that visa, or someone who has entered the US with some other kind of status, and either that status has expired or is about to expire, or it's still maybe valid, but they're affirmatively asking for asylum. When we refer to defensive asylum applications, we're talking about individuals who are already in removal proceedings. That means they were served with a notice to appear, and they are expected to go before an immigration judge. Notably, if you have an affirmative asylum case and asylum gets denied, that person will be most likely will be put in removal proceedings, and then they will have a chance to apply for asylum again defensively. Then either party who loses before the immigration court may appeal that decision to the Board of Immigration Appeals. There is one board that adjudicates all appeals nationwide. And then if the immigrant, if the non-citizen loses before the BIA, they have a chance to appeal directly to the federal courts of appeals, whichever one has jurisdiction over the place where the immigration court sits. So for instance, a case that was decided by the Chicago Immigration Court could be appealed to the 7th Circuit. So we can go to the next slide. And this tells us a little bit more about where the legal sources of asylum law come from, right? We have the INA, the Immigration and Naturalization Act, which also has parallel citations to the Chapter 8 of the US Code. Then we have a set of regulations under 8 CFR, which are also binding in all immigration cases. And then we have case law, right? As I explained before, there's only one Board of Immigration Appeals, so all of the published decisions from the BIA are binding on all immigration courts, unless they conflict with the Court of Appeals that has jurisdiction over that court. Meaning, again, if it's a case coming from the Chicago Immigration Court, the BIA precedent will be binding unless the 7th Circuit has opined on the same issue and the 7th Circuit precedent conflicts with the BIA, in which case 7th Circuit trumps BIA. Now, if we go to the next slide, we can talk a little bit more about the actual definitions of what asylum means. Most broadly, to be able to be eligible for asylum, you need to meet the definition of refugee. Now, and we provided a citation at the bottom of the slide of where that definition of refugee is defined. But in essence, a refugee is someone who has a well-founded fear of persecution perpetrated by the government or an entity the government is unable or unwilling to control, and that persecution happens on account of a protected ground, right? And we're listing all of the protected grounds there: race, religion, nationality, political opinion, and membership in the particular social group. And we're going to talk in a lot more detail about each of these elements. As you saw, we broke them down into different elements because we're going to address each of those individually in later on in the session. So next we have the statutory withholding of removal. And there may be multiple reasons why your client may not be eligible for asylum. I will point you to our asylum manual, which has an asylum bar chart, which outlines all of the different reasons why someone may not be eligible for asylum, but may still qualify for withholding or protection under CAT. And to be eligible for withholding, you have to show a clear probability of persecution perpetrated by the government or someone the government is unable or unwilling to control, and it also has to be on account of a protected ground. So what's the difference between asylum and withholding? Well, there's a few of them. One of them is that unlike asylum, which is discretionary, withholding is not discretionary. And then as you look at the elements, you'll see that the first element, the clear probability, is a higher standard than that of asylum. And then on the next slide, we can talk a little bit more about CAT, the protection under the Convention Against Torture, which requires a showing of that it is more likely than not that a person will be tortured or will be tortured either by the government or with the acquiescence of the government. There's a few, once again, there may be reasons why your client does not qualify for asylum or withholding, but may still qualify for CAT. And there's a few differences between CAT and the other forms of relief. One is that the amount of, or the severity of the harm to qualify for torture is much higher than persecution. But also there's no nexus requirement, meaning the torture does not have to happen because of a protected ground, right? You just have to show that it's more likely than not to be tortured for whatever reason. And also the government involvement, the government acquiescence requirement is higher than the unable or unwilling requirement we talked about earlier in the withholding and asylum context. And if we go to the next slide, we have a bit of a chart explaining some of the things I went over. But also, one thing that I would note is that beyond the legal elements, asylum has the most benefits to our clients. They're able to petition for their family to join them in the US. They qualify for benefits. They are able to travel abroad, and also they have a pathway to citizenship, which none of the other grounds for protection provides. So next, we are going to be talking a lot about the elements of asylum and breaking down each element. Once again, in the next slide, we're going to repeat the elements of asylum. And we're going to start on the next slide with the well-founded fear element. Actually, before that, we have some case examples. And I'll give you a minute or so to read over them. Don't worry about memorizing them. We're going to keep reminding you of the cases, but we are going to use both of these cases to illustrate our points about each element of asylum. Okay. Once again, don't worry about having to memorize the case examples. We're going to keep talking about them. But for now, let's start talking about the well-founded fear on the next slide. So what does it mean to have a well-founded fear of persecution? Well, to demonstrate a well-founded fear, you only have to demonstrate essentially a 1 in 10 chance that you will be persecuted. And there's 2 ways provided by the statute to prove a well-founded fear of persecution. One is that you can show past harm that is severe enough to amount to persecution, and that it means all the other elements of asylum, meaning it's severe enough to account for persecution, but it's also on account of a protected ground, and it's also harm that either was perpetrated by the government or by someone the government could not or would not protect you from. The other way is to establish a future fear claim, right? A reasonable possibility that you will incur harm that meets all of the elements of asylum. As much as possible, try to argue both, even if one is weaker than the other. And as you see, there's an asterisk on when we say there's 2 ways to establish asylum. There's a third way established by case law, which is humanitarian asylum. That's a very high bar, and it applies for people who have suffered extreme forms of past harm that may not be able to show a future fear, meaning maybe the conflict in their home country has resolved, right? Such that they no longer technically have a fear, but their past harm is so severe that they should still qualify for asylum. I will point out that this is not very frequent, and to the extent that we think it would apply to your case, this is something that your NIJC point of contact would flag for you if it applies to your case. So let's talk a little bit more about establishing a well-founded fear based on past persecution, which we can see on the next slide. As I mentioned before, you have to show harm that is severe enough to amount to persecution and meet all of the other elements of asylum. Once you do that, you have a rebuttable presumption of future persecution, meaning effectively, because this happened in the past, it's likely to happen again in the future. Now, the government can rebut that presumption based on changed circumstances or based on a demonstration that it would be safe and reasonable for your client to internally relocate in their country of nationality. So one thing I would want to flag as to change circumstances is that the mere passage of time, just because this happened 20 years ago, does not rebut a presumption of future fear, right? There has to be meaningful changes either on the specific circumstances of your client that led to the persecution or in the country as a whole. So then if we go to the next slide, we'll talk a little bit more about establishing a well-founded fear based on future events. And I will flag there's 2 prongs to this, a subjective element and an objective element. Now, we're not gonna delve too much into credibility and how to avoid adverse credibility findings in this lesson. We'll talk a little bit more about it on Thursday. But I do want to flag that credibility is very important for multiple reasons, right? If you're trying to establish a well-founded fear based on past events, an adverse credibility finding effectively just discounts all of your client's testimony as to their past harm. But also, even if nothing happened to your client before, an adverse credibility finding would preclude them from establishing a well-founded fear of future persecution. And then the objective prong really just goes to meeting all of the elements of asylum. Another thing that we wanted to flag, though, is that when you don't have a presumption based on past harm, you have the burden to show that there's no reasonable relocation. So that's a little bit different between the past and the future fear claims. But once you establish all of that, then you have established a well-founded fear of persecution, and you have demonstrated your client is eligible for asylum. So we're going to go back to the case examples now on the next slide. And we're going to do a quick poll. Okay, great. So most people answered that Aminatu could establish a well-founded fear, both based on her past harm and on her future fear. That's correct. We should argue both prongs as much as possible. I will say that in her case, just based on the case example as it is, establishing the past harm would be a little bit more difficult. But we're going to talk a lot more detail about that in the next few slides. So then if we go to the next slide, we can talk about persecution. And persecution is a legal term of art. There's generally two types of persecution. One is significant or severe physical force, physical harm, and then non-physical harm of equal gravity. And we say generally two types because different circuits have worded this differently, right? We have two citations there. For instance, the 10th Circuit says that there's generally two types of harm, right? Whereas the 7th Circuit says there's three different types of harm. Generally, the way we have framed it here would encompass most, if not all, of the circuits' interpretation of persecution. But I would flag that, especially if you're outside of the 7th Circuit, just look into the case law a little bit to see how that circuit has framed their analysis for persecution. Another thing to note is that harm that happens when your client was a child it has a lower severity threshold to meet the definition of persecution, right? Harm to a child, it's just considered to be more severe just because of the age than it would be for an adult. And several circuits have opined on this and held that this applies. But also, the harm needs to be considered cumulatively, meaning even if one specific instance of harm does not rise to persecution, the judge should consider the full history of harm, and if not individually, then in the aggregate find that your client suffered past persecution. So in the next slide, we have common forms of persecution for LGBT cases. Again, physical violence it should always bring and like raise a flag for you of past persecution. I will note that this is a very fact-specific finding, right? So when you have a type of physical violence that either require medical assistance or resulted in permanent damage or things like that, it's just much easier to prove that instance in itself rises to persecution, as opposed to a not so severe beating, right? But again, even if it's a non-severe beating that happened many, many times, at that point you're talking about the cumulative effect of all the beatings, and it would amount to persecution. Now, as far as rape and sexual abuse, that does qualify as persecution, but you have to demonstrate that it was on account of a protected ground, right? So either the sexual orientation or gender identity of your client. And as far as threats, threats may rise to persecution, but again, this is very fact specific, and the more serious, the more immediate the threat was, the more likely that that incident in isolation will rise to persecution. But again, even if it does not, you should bring it up in the cumulative. So we'll go to the next slide, and there's a couple of arguments as to past persecution that we at NIJC believe in, but that we acknowledge that in isolation may not be as strong, but still worthwhile to bring up, both because they are types of harm, but also because very often acknowledging these types of harm as harm allows your client to be able to tell their story fully, right? Which is one of our goals. So one of them is the inability to live openly or express your gender identity or sexual orientation openly. Again, this is something that a lot of courts are still having trouble with, but generally we bring it up in the cumulative context, and also we bring it up by fully explaining the extent of the psychological harm that an inability to express yourself openly would entail, and we bring out the psychological harm either through your client's affidavit, testimony, or even a psychological evaluation, right? And similar to that, a history of just pervasive discrimination and harassment, which frankly very often leads to an inability to live openly, is something that you should bring to the attention of the judge, even if discrimination and harassment in itself would not be a form of persecution. We should still ask judges to consider this cumulatively as part of the history of harm of your client. So on the next slide, we have our case examples again, and we'll have a quick poll. Great, so there was quite a bit of debate for this poll, and I'll just say that this is more of a conversation and a discussion than a right or wrong answer. I think the right answer is we would argue that all of those forms of harm amount to persecution, right? That's our first line argument. As far as which one is the strongest, you know, I think that because of Reina's age, the beatings that she faced as a child are, in the cumulative at least, most likely to be held to be forms of persecution out of the 3 examples we gave. Okay, so next we'll talk briefly about who the persecutor is, right? And who the persecutor is, really, to me, it's helpful to think of this as what level of government involvement was there in this case, right? And there's 2 ways to prove this. One, either the government was directly involved through a government actor who was actually the persecutor. And this can involve police, it can involve military, it can involve politicians who are in power. It can also involve, though, public school teachers, right? Agency workers, anyone who's a government actor or who's employed by the government and acting either through the power that job gives them or within their office would be considered a government entity. But also, there's another way of proving the quote-unquote government involvement, which is proving that the government is unable or unwilling to control a private actor. And who are the private actors? Basically anyone who's not a government entity, right? Gangs, an opposing political party, family members, basically any private citizen would or private group would be considered non-government entity. And I'll pass it over to Anisha to talk more about the next element.
Great, thank you, Tanya. So as you know, we've gone through 3 out of the 5 prongs, right? We've reviewed 1, a well-founded fear, of 2, persecution, and 3, perpetrated by the government or an entity of the government that the government cannot or will not control. So now we're going to move to the 4th and 5th prongs, which often is where you'll spend the bulk of time, kind of depending on the asylum case that you take. They can also be quite controversial and complicated, so it's just important that you pay attention to these. So in order to show that the persecution is on account of a protected ground, and again, these are 3 separate elements, right? So persecution is on account of a protected ground. Those are 1, 2, and 3 separate elements that are prongs, or I think we can just say elements that you need to prove. And you want to keep them separate because oftentimes the courts will confuse them and then confuse you. And it's just really important to remind the courts, a lot of what the work that we do is educating the courts on law. And so it's just really important to kind of break down these elements. And that's kind of why we're teaching it in this way or talking about it in this way. So whether the harm rises to the level of persecution, the reason or why it occurred, and whether the reason it occurred falls within one of the 5 protected groups, right? So whether the harm rises to the level of persecution, the reason or why it occurred, and then whether the reason it occurred falls within one of the 5 protected grounds, which as you can see is race, religion, nationality, membership in a particular social group, and political opinion. So the burden of proof for establishing the on account of element is one central reason. So just next slide, please. Great, so the statute says that in order to get asylum, the protected ground must have been at least one central reason for the persecution, not the central reason, not not the only central reason, but really like at least one central reason. So that has been interpreted to say that the persecutor can have mixed motives, right? And most persecutors honestly do have mixed motives, and that's okay. The protected ground does not have to be the only reason for the persecution. It just has to be, again, one central reason. The Seventh Circuit has said that to meet the one central reason standard, the protected ground can't be ancillary to the other reasons. It can be secondary or tertiary, but it can't be ancillary. And also keep in mind that it is perfectly okay to rely on circumstantial evidence to prove the nexus, right, or the on account of. So you'll hear me saying on account of and nexus kind of interchangeably, so excuse that if it can be a little confusing. Often you will have to rely on circumstantial evidence because you are likely not going to have a case where the persecutor is going to directly state their motive, right? Sometimes that does happen, don't get me wrong, but for the most part, you're going to have to rely on that circumstantial evidence. And when we have a case like this with a nexus issue, or when there is a case with a nexus issue, you know, there's kind of three types of evidence that we focus in on, and that's words and actions of a persecutor. So, you know, we'll get to Aminatu, but in Aminatu's case, you know, they said that quote unquote will fix her. So what does that mean? Trying to get around what that exactly meant and what the threat for her was, and what, you know, what others would assume that that threat meant. And then looking at the second type is like looking at the form of persecution. And this is rather important, so often with gender cases or sexual orientation and gender identity cases. So it's essentially the form of persecution itself can be really strong evidence, right, of why it occurred. So an example of that can be rape, right? We know that it's well established that this form of harm is often done to show power and control over somebody. And often with LGBT cases, we might see it in the form of like a corrective rape, right? If, you know, for Aminatu, can we interpret what the guard said to her as a way to, you know, clean her of her sexual orientation, right? Or to change her sexual orientation, or to remind her that she's heterosexual, whatever the idea behind that is, that can also be used as a form of showing nexus. And then the last thing that we do, or that we use in terms of evidence, circumstantial evidence around nexus, is country conditions, right? So looking for individual similarly situated in to your client. And that can be, you know, learning about the cultural context around, you know, different types of harm that somebody might endure in home country, such as rape, and why that often occurs, and does it occur often to individuals in the same protected group as your client. All things that are helpful in talking about nexus. And we'll talk more about obtaining different types of evidence a little bit later, but then also on Thursday. So we're just going to quickly jump into a poll. So next slide. And we're just going to jump into that poll whenever you're ready, Michelle. So I'll just give you all a minute or so, and then we'll discuss it further. Great. So most of you did say both, which is true. You know, she has nexus as to both grounds, and one does not discount the other, right? So there could be multiple central reasons for the harm. You just have to provide like proof or evidence, right, for each protected ground, that each protected ground was a central reason. So other evidence based on persecutor's words, right? We can use that in Aminatu's situation. And the type of persecution is, you know, when the persecutor said that they will fix her, often we see for lesbians, you know, harmed via like a corrective rape, right? As a way to quote unquote fix them. You know, and then country conditions evidence would also be useful in providing whether this happens often to women who advocate for the rights of LGBT individuals, or are LGBT themselves, And the fact that she was detained, during a protest, we can connect that reasoning could be also based on her political opinion, right? She was harmed while protesting, while essentially expressing her political opinion or her political activism, right? And just, not to forget Reina also, there is evidence that she was, beaten because of her gender presentation, it appears. But there's also evidence of her siblings being beaten. So how do we get around that? It's a lot of, obviously there's missing facts here, and it's a lot of, talking through with clients about that situation. This occurs often for many of our clients, I believe. And so the answer there is that she was beaten extra, more than the other siblings. And why was that, right? So you can argue nexus as to her perceived sexual orientation or gender identity, even though there's factual evidence that her siblings were also beaten, for minor infractions, as it states. And there's obviously a lot to tease out in these, and if given more time, of course we would. But this is just to give you an example, and with more time, we would delve in more. But it's just hopefully helpful to see how each one of these elements are connecting to a case example. So next slide. So yeah, so now we're going to talk about the protected ground, number 5, right? So this is the last element of asylum, and essentially, again, this is what was the reason you were being harmed? What was the reason you were being harmed? And so remember, there are 5 protected grounds. There's race, religion, nationality, political opinion, which can be actual or imputed, and then membership in a particular social group, which is the most common and often most complex, depending on the type of asylum case you're doing. So for race, religion, and nationality, they're pretty self-explanatory. We honestly don't see a lot of these cases, but when we do, they're pretty straightforward. The case law is straightforward for the most part. With political opinion, as I mentioned, it can be actual or imputed. So for Aminatu, it would be actual, right? She protested in a political action. We're assuming she's politically active, and that she holds certain political beliefs, right? Or beliefs in, for example, the human rights that she believes in. Or, if let's say she was, that the government or the persecutor just believed, maybe she was just walking down the street and they thought that she was part of the protest and they picked her up. And so the persecutor harmed her based on their imputed or their belief that she had a political opinion, even if she didn't have one. So it really doesn't, it's okay if she doesn't hold those beliefs. It's based off what the individual persecutor believed was her political opinion. So we're going to focus on the particular social group, which is the last one, membership in a particular social group. And that's because this is the most common for LGBT individuals and often the most complicated. So for a particular social group, it's not defined by statute, but the Board of Immigration Appeals first defined it in matter of Acosta in 1985. And it's essentially to have a group of people with a characteristic that you cannot change, right? Like race or nationality, or that you should not be required to change, like political opinion or in religion. So they were trying to connect it to the other protected grounds, right? What was unique about those other protected grounds? How do we establish that within a particular social group? So this was the definition for over 2 decades. And until we started seeing these kinds of attempts to restrict asylum based on membership in a particular social group. And what we started to see is happening is the BIA issuing additional decisions with added requirements, right? So right now we're seeing a circuit split because in the 7th Circuit, actually, it continues to use the Acosta definition and only considers immutability, while the BIA has veered and most other circuits have actually developed a more narrow definition. And again, this is all like very much explained in the asylum manual, but then we also have a particular social group practice advisory that if you believe that you need to know more about particular social group, you can definitely look to. You'll notice, and I'm about to move to the next slide, but not yet, that particular social group, the definition is in flux, and as I mentioned, different courts are interpreting it differently, but at its core, it's an immutable characteristic, and thankfully, for the, for right now, the LGBT cases specifically, we have strong case law that has not yet been challenged. So providing proof that LGBT individuals are part of a particular social group is pretty clear. And so we don't see a lot of I guess, interpretation around that. And so I just want to make sure you all are aware of that, and that if you feel like you want to learn more about a particular social group, that you please look to our practice advisory that is very clear and in depth about that. So you can move to the next slide. So as I mentioned, for particulars for sexual orientation and gender identity cases, we have pretty clear case law. Generally, again, it's complicated, but again, for LGBT cases, we don't have that issue as of right now. And obviously you're going to see from this slide, the case law is pretty far behind in the way that they reflect our clients' identities. And so it's really important, or the way that they previously reflected an individual's identity. So it's really important that we don't follow exactly what they're saying there. Like, for example, in Hernandez Montiel, we wouldn't use that particular social group. We wouldn't say quote, gay men with female sexual identities, end quote. We would use, what the client identifies with. So let's say for Reina, if she currently identifies as a transgender woman, we would say a transgender woman from Honduras, right? Or Honduran transgender women. As you can see, for sexual orientation, it's been around since 1990 that it's a particular social group. I believe that social group was also maybe not the best. And so, for somebody like Aminatu, we would probably say that she is a lesbian from Guinea, or Guinean lesbian women, and so forth. So then, with HIV cases, it's important to note that it's standalone HIV cases are very difficult, but we have been able to prove that sexual orientation can be imputed in certain countries where an individual is HIV positive. So in Velázquez-Venegas, the Seventh Circuit recognized that while HIV is a virus that infects a wide variety of individuals, there is a widespread association of HIV with members of the LGBT community in Honduras, right? So based on this perception, the court acknowledged that Mr. Velázquez will be perceived as gay based on an HIV status, and thereby at risk of serious violence in Honduras, as is in the case of many members of the LGBT community in that country. So Mr. Velázquez does not identify as a gay man or is part of the LGBT community, but because of his HIV status, he feared that individuals in Honduras would perceive him to be gay, because that was the cultural norm as far as he knew it. And we were able to prove that as well in that case. So just move on to the next slide. I know I already mentioned this a little bit prematurely, my apologies. But Aminatu, again, straightforward PSG, is lesbian women from Guinea, but also remember that she has the additional protected ground of political opinion. So you'd want to make sure you brief both of those, and we'll talk more about briefing and all of that on Thursday, but just making sure we don't, that we reserve all arguments, and including her political opinion. With Reina, it is more complicated. I know I mentioned transgender women from Honduras, or Honduran transgender women. However, for her case, it's more complicated, right? So she's got overlapping particular social groups based on her identity as a trans woman, but also based on how she was or is likely to be perceived in Honduras. So one, maybe as a transgender woman, and then two, gender nonconforming, right? Gender nonconforming individuals from Honduras, Honduran gender nonconforming women, or trans women, we can also talk about her perceived sexual orientation, right? So we don't know exactly why, she may or may not have been harmed in home country. It's not always clear as to what the actual reason is. So we try to cover all those bases. So let's say, we don't have a lot of facts for Reina, but let's say in home country, she was perceived as a gay man. So then we'd say, like, perceived gay man as well. We tried to include those so that we can explain the past harm, but then also the future harm as a transgender woman, right? Because now she identifies as trans. Again, it's complicated, and it really kind of depends on the case. Like, so, for Reina, like we would of course want to use that she's a transgender woman and that's her protected ground. But for her past persecution, we would want to cover that by using either gender nonconforming, gay men or gender nonconforming individuals. So it just kind of depends on the case and what the facts are. Obviously, there's a lot more that may have happened to Reina in home country, and so we want to suss all that out before we kind of settled on particular social groups. So just next slide. Great. So we're going to talk a lot about evidence and all of that, but I think it's really important to mention around how to prove membership in a particular social group, because proving it is a lot around credibility, right? So it's important to obtain credible, detailed, and consistent testimony from your client. This includes written materials, but also oral testimony. And the additional evidence that you can get is from third-party affidavits from past partners, medical providers, psychologists, family, friends. Like, those are really important. It seems rather silly, in my opinion, probably in many others, that somebody who identifies, let's say, as Aminatu does, as a lesbian woman, that she would have to then go and try and prove that in some way. And how do you prove that? And what kind of weird things do people think that, or would, what kind of things would an adjudicator want to see? It can kind of strange at times. So, for sexual orientation, it can be many things, right? It can obviously be the word of the individual, but also, pointing to past relationships, potentially like LGBT activism, like Aminatu, meaning the participation in gay rights groups or parades or protests, things like that. It's also in here and in home country, right? So let's say like Aminatu the political opinion part wasn't a part of her case, or let's say Reina, is now here in the US and she is she's involved in LGBT human rights work, then that would be relevant, right, to her case, and in proving that she's part of that particular social group. So, it's important also to remember the difference between conduct and identity, or sexual orientation and sexual activity. So your client may identify as a gay man, even if he has never had a boyfriend, right, or engaged in sexual activity with another man. People can have a sexual orientation and still be abstinent, and that's important. So oftentimes we have to, it seems like very obvious, information, but judges and adjudicators can sometimes not understand that there's a difference there, and that sexual activity is not the only thing that proves somebody's sexual orientation, right? And so, we've had clients who have not, partaken in any sexual activity or had boyfriends before, and those are still viable cases. In those cases, you have to challenge is to identify other forms of proof and having others vouch for your client. So that will be really important when you're doing that. And then on the other hand, there are lots of individuals who engage in same-sex sexual conduct, but who are not ready or able to identify as gay, or may never identify that way, right? This could also be a viable case as an imputed claim. So it's always important to check in around those things. So again, it's important that we don't allow the court or government to focus in on sexual activity. That's not the point of somebody's sexual orientation. That's not the only thing that proves sexual orientation, right? Moving on to bisexuality claims, they are among the more difficult particular social group cases. However, there are many times they are viable, and your job is to provide the sufficient evidence or detail in your client's affidavit, in your testimony, as to their bisexuality, and to remind a judge or asylum officer that bisexuality is a sexual orientation and a protected group, right? So this is really important that we do that. And there's two cases, one in the 7th and the 2nd, that talk a little bit more about that. Fuller being, he was a bisexual man from Jamaica who was denied withholding in CAT, protection under the Convention Against Torture, The majority found that there was no error in the IJ's adverse credibility finding, and the dissent from Posner criticizing IJ for being closed-minded and biased towards claims of bisexuality and for demanding proof that did not exist. So there is, ways in which we can talk, we can push against this idea that bisexuality isn't a viable protected group, right? And there's ways in which courts are doing that and advocates are doing that. And then moving, to gender identity, I mentioned Marina, apart from the client's letters and I'm sorry, the client's affidavit and affidavits from family and friends, if the client has transitioned at all in terms of, the process of beginning to live in the gender that feels appropriate to the person, that could be via, medical records, if they've, taken hormones or a psychological report, a letter or affidavit from a nurse, social worker, therapist are usually helpful in addition to the client's own, testimony. And I will just note that medical intervention is not a requirement, right? It's not necessary. And so, that you should steer away from that deterring you from making a claim if the individual identifies as transgender. The medical intervention is not necessary, and everyone kind of has their own transition process, and it could be one day or it could be many years, and so you have to be open to that, those complexities. And then clients living with HIV, the results for the HIV test are sufficient, but keep in mind that if a client's HIV status is also going to be used to make an exception to the 1-year deadline, which we'll talk about in a little bit, you will likely need to obtain proof of when your client learned of their HIV status, along with the test results, a letter from a doctor or nurse who will be willing to, prove time period of finding an HIV status. And we can talk more about that if you have a case like that, right? And then imputed sexual orientation based on HIV status. We talked a little bit about that. If a client with HIV in country of origin, their experiences along with the country conditions will be essential to proving, the perception in their country of origin is that, that HIV positive individuals are members of the LGBT community or are one in the same, right? So, also affidavits from family and friends from their country are helpful. And if possible, in these kinds of cases, an expert who can link the perceptions of individuals in your client's country around HIV status and sexual orientation is key, right? So last, we'll be discussing presenting your case during part 2 of our presentation. I'm just kind of getting us started a little bit, which that part 2 will be on Thursday. And then just the last thing, next slide. 1-year filing deadline comes up a lot with our clients, and often, because they're unaware of eligibility for asylum, they may be coming out later, years later, and as LGBTQ, right? Once they're here in the US, there can be many reasons why people don't seek asylum within a year of entering, and that is an added requirement that individuals who enter the US file within a year of their date of entry, I believe in 1996. So it's fairly new and fairly reversible. So moving on to the next slide. So there's 2 types of ways that we can prove an exception to the 1 year. So there are ways in which you can, if your client doesn't file within a year, there are some ways in which we can argue that they should be granted or they should be, allowed to have there should be an exception to their 1 year, right? So there's 2 ways: changed circumstances and extraordinary. And, the regulations discuss several categories for changed circumstances, which can be changed country conditions, changed personal circumstances, changes in applicable US law, and then loss of derivative status. So the first category of changed circumstances is changes in conditions for applicant in home country. The most obvious one of being, let's say, if, for example, a new law criminalizing same-sex conduct were to be enacted in their home country, right? And then, as a second, an alternative, and one that for LGBT individuals comes up a lot, is personal circumstances, such as being outed or discovering HIV infection. would affect their ability to live safely in home country and are included as changed circumstances. So these can be an argument for why they're seeking asylum outside of their 1-year filing deadline. So one's, as it's listed, being outed, coming out, right? Starting to transition, beginning a course of medically supervised home treatment. These are just examples. And then for extraordinary circumstances, the idea behind changed circumstances is that an applicant now has a claim for asylum that they may not have had when they first arrived in the United States. The idea behind extraordinary circumstances, though, is that some circumstance that manifested itself while in the United States prevented the applicant from filing. So oftentimes this is around mental health, and you're able to make those arguments there. Another key exception is falling out of status. It's a little bit confusing, but let's say if you have you're working with a student, they must file within a reasonable. They're in status for years. I think Tanya mentioned that there's some individuals who come in on different types of visas. Let's say they're on an F1 student visa and they're on that, they're on that status for a while. And then, they have to file within the time period, before falling out of status or within around 6 months of them falling out of status. It's a little bit, there's not clear case law on this. So we always try to encourage individuals to file before they fall out of status to ensure that that there's no complications around whether they filed within a reasonable time, which is the requirement if they're out of status, or if in the case of any of these changed circumstances or extraordinary circumstances, you would want to also file within a reasonable time of that changed circumstance or that extraordinary circumstance. So we can move to the next slide. We're just going to do a quick and our last poll, I promise. Whenever Michelle can get that up, that would be great. So just give you about 30 to 45 seconds to respond. Okay, so it was a little mixed, but the majority of everyone, said that Reina, which I would agree with. And the reason why Aminatu, wouldn't have a 1-year filing deadline issue is, she was recently, as it states it, she was recently detained upon arrival to Chicago O'Hare Airport. So I guess recently can be interpreted in different ways, but let's say that was just a couple months ago. So she's still detained. We can file within a year of her entry. And again, even if a client is released and you're working with them, we have to ensure that we don't miss that 1-year filing deadline. It's so important. And so, we would make sure that once we took Aminatu's case, that we went and was placed with a pro bono, that the pro bono and us were on top of making sure we don't miss that 1-year filing deadline. And that's something that we work with our pro bonos closely on, to ensure that doesn't happen. Where the 1-year filing deadline really comes up is with Reina. It's more difficult, but she's been here, since she was a teenager. So let's just say she's been here at least a year after she turned 18, right? Just to note, when somebody is under the age of 18, there is an exception to the 1-year filing deadline there. But once they reach the age of 18, they need to file within a reasonable time, which we've essentially thought around 6 months or before they turn 18, right? But for Reina, she's 25 now. So she's been here for, let's just say she's been here for at least 5-6 years, right? And so how would we go about proving that she should be eligible for an exception to 1 year? We would focus in on her transition, right? When did she start transitioning? It says just a few months ago. Okay, what has she done? What does it mean to her to have transitioned or begun transitioning? Is there any steps that she's going to be taking at a later point that may, increase her likelihood of harm and therefore and her fear, and therefore, give us a new timeline around the 1 year. We just have to, kind of work through that and ensure that we have the strongest possible arguments to the 1 year. And obviously there's a lot of facts that we would need to get out of working with Reina in order to make that argument the strongest it can be. Next slide. All right, so other considerations. We're just going to move to the next slide. So obviously, or maybe not obviously, because I think it's going to be on Thursday that we talk about this more. We do have cases where, individuals are in proceedings for a very long time. And things happen, good and bad, while they're waiting for their case to be adjudicated. One thing that comes up a lot is marriage. Now, it's really important that from the day one that you're working with your client that you talk to them about things like this, meaning like ensuring that they know that if any changes happen to them, not just their address or phone number, but if they meet somebody and they're thinking about marriage, or if something bad happens to them, like they're a victim of a crime, that they feel comfortable and they trust you enough to come to you. So building that trust from day one is so important, because these kinds of things do come up and you want to make sure that your client feels comfortable bringing it to your attention. And you also just want to make sure that your client understands, that you understand that oftentimes, clients will feel, they're in dire situations. They are afraid they're going to be returned back to their country, and so they're thinking of alternatives, right? Not always is the case that they're thinking of marriage just for immigration purposes, but if that is the case, we want to be able to know about that so that we can talk them through it, and so that they're not thinking that they have to enter into relationships that are not going to actually be helpful. It's just really important that your client understands that marriage definitely does not solve their status. It doesn't provide them with a permanent status, even if they marry a U.S. citizen. It really, there's a number of factors that might prohibit them from being able to adjust their status to that of a lawful permanent resident or green card holder. And more recently, we've seen, harsher restrictions on family petitions, and the increase in need to show, proof of income and things like that have not always been there in the past. So, it's not a thing that solves all status issues. So you just want to make sure that your client understands that, and that if your client is asking you questions about marriage, that you just kind of ask them, oh, are you dating somebody? And if they're not, if it's just overall, we're happy to talk to you and the client about what marriage may look like what their marriage to a U.S. citizen or lawful permanent resident may change in terms of their asylum case. But it's just important that they feel like they can come to you about those things without judgment. And yeah, so then the next is, a victim of a crime. Often, this happens to our LGBT clients. They're subject to harm here, sometimes similar to the harm that they're subjected to in home country. And so again, it's important that you share this information with us so that we can talk through with you what your client may be eligible for. There are different types of reliefs for victims of crimes. It's important, again, to let us know, but then also so that we can discuss the potential for this eligibility, but also to be clear about the fact that sometimes it takes even longer than an asylum case. So we just want to make sure that we're just in contact about that. And then travel, again, they are able to leave the state, but you want to just make sure that they understand that there's different rules around the border, and it's just important that they check in with you about that. And then just lastly, around this, you just want to make sure your client doesn't file applications without consulting you first when it comes to your immigration case. It's really important. Your representation is for their asylum case, but their other applications can affect their asylum case. And then just lastly, around external factors or changes in law or policies, so many external factors currently affecting our asylum seekers or affecting asylum seekers. And so instead of going into all of the current bans right now, and instead we've provided you with the chart that I mentioned earlier with information about the current bans. And often these affect individuals that are not yet in the country, but we do work with clients currently subjected to some of these bans, like the the travel ban. So we just want to make sure there's like a transit ban that we just want to make sure that you know, if that is applicable to your client, that we talk to you through that and we talk about a strategic plan to address those bans and to reserve arguments. And so we can do that all with you. But that's just a handout to hopefully help with understanding the current landscape of what we're looking at with asylum restrictions. And then just lastly, you know, we have practice manuals on matter of AB, which ended asylum based on DV and gang violence, and also on matter of LEA that ended asylum for, you know, family-based claims, or often it made it more difficult. So both can be found on our website, and I encourage you to look there. And then just last slide. I just want to thank you all for joining us during this presentation, and I hope that you'll join us on Thursday as well. And of course, I hope you decide to take a case. You know, you can find our pro bono list on our website or by emailing Michelle. And if we were unable to get to your question, or if you have further questions, please reach out to Michelle and we'll respond as quickly as we can. And again, remember, we do have part 2 of our training on presenting and preparing an asylum case this Thursday at 2 p.m. Central. We'll dive more into the type of evidence to gather, and we'll have a section specifically on how to work with LGBT clients, you know, adding on to what Michelle already discussed earlier in the presentation, as well as advice and tips on working with LGBT individuals who are detained. So just in case people are interested, this webinar is being recorded and will be available at on our website within about a week. And just lastly, we really value your feedback, so you can hold your phone up to this QR to complete the brief survey, or we will be sending you a link in the follow-up email, so you can fill it out in that way as well. And I think there's a question about slides. They are available. They're in the handouts. They're one of the handouts. So please feel free to hopefully download those, or if you're unable to download anything, feel free to email Michelle and she'll get back to you as soon as she can with those. So that concludes our presentation. Thank you again for everyone who joined, and we'll hopefully see you on Thursday.